Hello, good morning. January 2nd, 2019, here from the Philippines. And I'm going to give you another lesson on just how judges cheat us out of our civil rights and why we actually don't have civil rights. Um, and to do that, first I'm going to talk about due process. Give you a crash course in due process. So basically, due process, it's fundamental constitutional right by the 5th and 14th Amendments. The 5th, federal government; 14th, it's extended to the states. And without due process of law, we really have nothing. Okay, so what is due process, right? Well, let's look at the two words, due process. First, we have due. The government owes it to you. When the government's thinking about taking your property, your liberty, anything that you have a protected right to, something that you own, the government owes you process. It's due to you. So what is process? What do they mean by process? Well, process is simply legal proceedings. So when the government wants to take something from you, it owes you some legal proceedings, certain set of legal proceedings, and due process defines what legal proceedings are owed to you. Now, when are they owed to you? Like if it's before the government deprives you of your property, it's called pre-deprivation. It means they owe you the legal proceedings before they take your property, they take your liberty, they take some other protected item from you. Something that's your protected speech, whatever you want, whatever is protected by the Constitution. Before they take it from you, uh, they need to provide you legal proceedings. Okay, when else can they provide you legal process? Well, under the law, they can give you post deprivation. They can take it from you first and then provide you some legal process, legal proceedings after they take it from you. But they can only do that in the case of an emergency. So there has to be some real pressing need to take your property, take your liberty, um, and then give you legal proceedings. And it's supposed to be used under the most dire of circumstances. Okay, so let's go. So now, what is legal? What is legal process? What are the legal proceedings that they owe you? Well, first of all, at the bare minimum, and this is all we need to talk about in the beginning, the bare minimum, they need to give you full and fair hearing on the issues. All right, you need to have all the issues come to the table, and there needs to be a full set of procedures, which includes discovery. It includes finding out what charges are against you, you giving a chance to confront your accusers, and so forth. That's what they mean by full. And then fair, it has to be fair. Like, what good are legal proceedings if you have, like, say, a biased jurist, or the government's witnesses are lying to get what they want from you. So the bare minimum is it's fair. And if you don't get full and fair process, then you're not meeting the due process requirements. What else is required? Well, the issues are necessarily decided. In other words, the things that really matter to the case, the things that are material to the case, they have to make a decision on the decision as to whether the facts are true or false. So the issues have to be decided. And you have to know what the issues are in order to decide on them. These are the bare minimum requirements of the legal proceedings that the government owes to you when it wants to deprive you of your property or any other legally protected right that you have. Now I'm gonna give you I'm gonna go to my particular case, and show just how judges cheat us out of this due process. You know, I'm making a claim. I'm making a due process claim. I'm claiming that the government violated their responsibility to provide me full and fair legal proceedings. Okay? And the judge dismissed my case. And here's the ruling in which she dismissed my case. And what I want to focus on is what's highlighted in blue. Plaintiff cannot challenge in this forum the integrity of the process. Well, that's completely nonsensical. So what she's trying to do in making this decision is saying, I can't make a due process, I can't challenge the process in a due process claim, which completely goes against the grain. So here she's ruling against me, saying I can't challenge due process in a due process claim. So she just cheated me out of my civil rights right here. And nobody, like if you're reading this, you're just gonna gloss over it, and you're not really gonna take the time to understand what she's saying. She's saying plaintiffs cannot challenge in this form the integrity of the process. Well, what if the process doesn't have integrity? Well, it's not fair. If somebody's lying on the government side, and those lies are accepted by the decision maker, then you don't have that process lacks integrity, and it's not fair. So where do you challenge that? If you can't challenge this in the federal court, you can't, or any court, you can't challenge it anyway. So you don't have the right. So here she makes the decision, and it's just absolutely bizarre. So let's delve into this a little deeper and see what my complaint was. Why did I say it's unfair, the proceedings? So this is what I'm challenging. I'm challenging this vacate order. Okay, this is a picture of the vacate order right here, and what you see down here highlighted in blue is signature, and underneath the signature it says that it's the borough commissioner, and it's dated 6/14/2013. And when I first saw the signature, I don't know what that scribble in front of Derek Lee's name is, but Derek Lee is the borough commissioner for Queens, and then it has some scribble in front of it, which I didn't know at first what it is. Now I know what it is now. I'm not going to let on to what it is at the moment, but we'll see later on. So this is what I'm saying. I'm saying that they should have never issued this vacate order, and they're saying now, not before. They're saying they issued this vacate order on an emergency basis, which they didn't. That's not true. It doesn't say that anywhere. In any case, I should have been afforded a pre-deprivation legal proceeding, but I was afforded a post-deprivation legal proceeding. Well, let's see what happened in those post-deprivation proceedings, okay, where I challenged this particular order. So here is the sworn testimony from the inspector. His name is Pugak, Inspector Vladimir Pugak. And he swore before New York State Supreme Court when I challenged that vacate order. He swore that he did this. He said he swore that he recommended to the Queensborough Commission of the buildings that he issue a vacate order because of the imminent danger to life and safety of the occupants. And then the Borough Commissioner issued a vacate order. Okay, so he's saying that he went to the commissioner. Of course, I'll point out, he says imminent danger to life. That's not an emergency. That's an imminent danger. That's imminent danger to life. Any class 1 violation in New York City is considered imminently dangerous to life. So he's admitting that he's not doing this on the basis of an emergency, which should tell you that I should get pre-deprivation remedy right there. But more importantly, he's saying he recommended the Queensborough Commissioner, who happened to be Derek Lee at the time, still is Derek Lee, and that the Borough Commissioner issued a vacate order. Okay, so this is Pugak's testimony. Now we go to the next page. We just see that the testimony was dated June 25th, 2014. The vacate order occurred on June 14th, 2013, and this is where he's making the sworn testimony about him going to the commissioner. So, and here on the next page, this is the attorney Weinblatt to the New York in defending Derek Lee and the vacate order to New York State Supreme Court. And this is an affirmation, like she's she's affirming this. So she's swearing this as well. So she's swearing that the DOP commissioner is authorized by the administrative code to issue an order to vacate the premises. Now, she doesn't mention anybody else. She mentions only the DOP commissioner. Vladimir Pugak swore he went to the commissioner, and she's swearing that the DOP commissioner is the one that's authorized by the administrative code to issue the vacate order. And here's an excerpt of the law below. And I just highlighted the pertinent parts to try to strip out all the extra verbiage to make it simpler to understand. And the law says, in case any order to remedy is not complied with, or the commissioner, and again, they mention commissioner explicitly, determines that an emergency exists requiring such action, the commissioner, and nobody else, may order and immediately cause any building, structure, place, or premises to be vacated. So Pugak went to the commissioner. Weinblatt says the commissioner is the one authorized to make such an action, and the law explicitly says the commissioner. Okay, so let's go on to the next one. Here is the brief, the appellate brief to New York State Supreme Court, and this is done by Amanda Sue Nichols. She's an attorney for the New York Law Department, and I opposed the decision of the lower court. We went to the appellate court, and she says in her brief, and she's under oath here too as well, she's swearing, the decision to issue a vacate order must be made by the DOB commissioner. Okay. And then she signed this November 25th, 2015. So you see, we're already ahead 2.5 years almost. Amanda Sue Nichols. And we go to the next. And here's the decision by the New York State Supreme Court. And he's referring to the commissioner's determination to issue the vacate order. Okay, so here he got the appellate division got that fact from someplace, the commissioner's determination to issue the vacate order. They got it from the record. Well, the only place they could have gotten it from are the two attorneys and Vladimir Pugakis. There was no other testimony in the proceedings, in the legal proceedings. And then they happened to conclude that the commissioner made the determination to issue the vacate order. And then we'll see that this is dated, if you see it on the bottom, March 15, 2017. Okay. So here's just before this decision came out, here's a big revelation, and it's coming up on the next page. Okay, I'm getting ready to depose the Queensboro Commissioner, Derek Lee, and I'm going to depose him in 2017 in March. And just prior to that, I get an email from Amy Weinblatt, the New York Law Department, the one that wrote the affirmation that we just saw earlier. And this is dated March 14, 2017, the day before I got the decision from the New York State Supreme Court. And she says, oh, I want to point out that the Borough Commissioner Lee did not himself personally sign the vacate order at issue here. So you're saying the commissioner can issue the vacate order. Commissioner is the only one that has the right to. You swear to New York State Supreme Court. The Vladimir Pugak swears that he went to the commissioner and the commissioner issued a vacate order. And now you're telling me, well, the commissioner actually didn't sign it. Somebody else signed it on his behalf. Oh, that's news to me. So now I'm saying, wow. Okay, so what actually did Lee know about this? And she's trying to get me not to depose Lee. Actually, that's what she wants to do. But I went through with the deposition. So let's go ask Lee at the deposition. And here is where I ask him the questions about when he actually knew about the vacate order. So you see the question. This is an excerpt from the transcript. After I deposed Lee, a transcript was produced, and these are the results. So the Q's are mine, the A's are Queensboro Commissioner Derek Lee. And I asked him, when did you have knowledge that he signed off on this particular vacate order on your behalf? When I first looked at the vacate order. Well, when was that? Well, that was after I received documents regarding this case. That's the first time I looked at the vacate order. Well, Lee didn't receive documents that he was served on this that he was served in this case until more than a year after the vacate order was issued. So Ho couldn't have signed it on his behalf because Lee knew nothing about it. You only sign something on somebody's behalf if they know, if that person knows what you're signing. So actually, the Weinblatt was a little misleading. Lee had nothing to do with the issuance of the vacate order in reality. So now what does that mean, man? Bugak lied. He said he went to the commission. He didn't go to the commission. He said the commission issued a vacate order. The commission didn't issue the vacate order. He knew that the commission didn't issue the vacate order. He knew exactly what he did. And you know, it's just bizarre. And that's absolute. And false testimony is perjury, and it makes the unfair proceedings. And it also makes the decision that the New York State Supreme Court Appellate Division issued impossible. It just could not have happened. So let's see what Bugak actually did. Okay, when Bugak went to get the vacate order, all he did was write an email. He wrote an email, and you see the email at the bottom. He wrote it at 8:12 a.m. on June 14th. And these names below, Dennis Embody, Bernard Kirk, Kine, Camera, Matera, they're all inspectors. These are all inspector grade employees of the Department of Buildings. Some higher ranking inspectors, some lower ranking inspectors, but inspectors nonetheless. Nobody with any authority. And then he just makes a few statements, request vacate order for the premises. He doesn't even recommend, he requests. He's just saying, okay, just give me a vacate order. And then at 9:43, you see the email up above. 9:43 a.m. Paul Matera responds to him, okay, I'm going to give you the vacate order, just forward the copies of your ECV violations. And then 11:53, he's saying, okay, is the vacate order ready to pick up? And that's it. That's all he did. No recommendation to the commissioner, only inspectors, other inspectors. And he didn't make a recommendation, he made a request. So you be the judge. What did Bugak do? He lied under, as far as I can see, you can't deny it. He lied under oath to get the decision. Now, I bring this up to the court, to the Magistrate Judge Lois Bloom, in a court conference. And I said, you know, they submitted perjured documents to the New York State Supreme Court. And what you see, this is an excerpt from the transcript of that conversation, that conference with the judge. And she says, well, if you're saying that the defendants in this case submitted perjured documents to the state, well, that's something you could certainly make as part of your claim that you would deny due process. Okay, and that's exactly what I'm saying. And that's exactly what I've proven right here. And that makes sense, because if the only government actor that's giving testimony in support of the government actions unopposed lies, that's unfair. That's not due process. That's a due process violation. You're not getting your due process even after the fact. I mean, I say I should have got it before. Yeah, I'm making my little video.
Thank you for breakfast, for birthday.
Okay, 1 second, man. 1 second. I'm almost done. Okay, so yeah, the magistrate judge is saying the truth here. She's saying, well, that's certainly a due process error if you were not provided fair process here. So I think I'm in good shape. And then she rules against me. She says I wasn't denied due process. Now, this was a revelation. So what I did was I wrote my objections, and I pointed out to the district judge, Ham Chen, and I say, you know, plaintiffs object to Bloom's report, its continued reliance on New York State's Supreme Court's ruling that Queensborough Commissioner Lee properly issued a vacate order, because it's now known that Lee knew nothing of the vacate order. And you see it. I mean, you can't even deny it. All this proof was submitted to the court, and all the references and so forth. New York State Supreme Court relied on Prokop's sworn false testimony that Lee issued the vacate order. I don't need to read the rest of it. I think it's pretty clear. And Bloom said that if I submitted proof, if I submitted evidence that they lied, that, that could be part of my due process claim. And it was. Okay, so how did she handle that objection? Objection number one. Well, here's the order. I mean, I showed you an excerpt of this earlier. Plaintiffs cannot challenge in this form the integrity of the process. And then all she's saying is objection one, which I just showed you, concern the legitimacy of the vacate order imposed on the plaintiff. Well, actually, I mean, that's really not a totally accurate categorization. I mean, objection one challenges the process, right? And that this is a due process claim. I'm challenging the fairness of the process. She doesn't say that here. And then she says, Judge Bloom repeatedly instructed plaintiff when presented with these same arguments that, I can't challenge the integrity of the process, but that's not what she said. So she's like, so here she goes again, Miss Pam Chen, judge, federal judge, liar. She just lies. It's unbelievable. And people read this stuff and say, oh, wow, man, Lewis really, he's bringing this claim and he doesn't really have any grounds to bring it. Well, here it goes. And, you might not think that this is like a serious matter, but when judges do stuff like this, even if it's one person, it means they could do it to other people. And what it means is that your last line of defense to protect your civil liberties are non-existent. And if you don't have any defense against violations of your civil liberties, then you don't really have them. So that's my case here, and that's my little lesson in how judges cheat us out of our civil liberties. Okay, and I'm gonna end that here. If you have any questions about this, feel free to ask me. If you don't understand what I'm trying to get, some of the evidence, some of the proceedings, and so forth, I can give you all of that. And I feel like I've become an expert in this stuff right now. So have a great day.